as a reminder. Thank you for that. So my name is Alexandria Scott. I'm a public engagement coordinator focused on the East region with the Oregon Water Resources Department. I will be your facilitator for today. As a reminder, this is the 5th session in a series of sessions that the Oregon Water Resources Department has been running through August 2023 as part of the Division 512 rulemaking education and outreach. So these sessions were asked for by our Rules Advisory Committee and the community to serve as a learning tool to better understand the groundwater control tools that the department has and build a foundational understanding so that we can enter these rulemaking conversations prepared and answer any questions you may have before we dive deeper into these subjects. As a reminder, these sessions are recorded and posted on the splash page for Division 512 on our website. They're typically made available within a couple days, and they have little accordions that have the PowerPoint slides and the recordings available for you. As a couple ground rules as we get started, we're going to do things a little bit differently. We're going to follow a similar format as we did for the voluntary agreement session, where we will take questions along the way instead of saving questions until after the presentation. So I'll just ask you use the hand raising function or physically raise your hand if you're on camera. And then you can also drop questions in the chat and we'll be monitoring that as well. So that is a little bit of ground rules and how we'll be doing the session today. And with that, I will turn it over to our first presenter.
Thanks, Alexandria. Kelly, can you guys see my screen? All good there? Excellent. So as Alexandria said, my name is Tim Seymour. I'm the assistant manager for the groundwater section. And I'm going to be presenting today on the Division 10 critical groundwater area designation rules. We had recorded a longer version of this presentation and put that up on YouTube, sent it out ahead of time. Hopefully many of you had the opportunity to watch that and listen to me talk for 40 minutes. If not, we're going to go through it in an abbreviated fashion here and try to take questions as we go. So I'm going to try to pause at breakpoints throughout, and we'll talk through questions that came up on that particular set of slides or content. So as Alexandria said, raise that hand. Pop something in chat, and Kelly and Alexandria, if you could help me make sure that we get that stuff answered, I'd really appreciate it. So let's get started. So in previous informational sessions, we've shown this same chart. I'm not going to belabor it. We've talked about it many times. Today, we're going to be talking about critical groundwater area designation, and that is a control tool that is focused on present groundwater use. As we've talked about previously, we have these other tools. The ones that are applicable to the rulemaking for Division 512 are classification of water, which focuses on controlling future new groundwater use, and then the serious water management problem area, which focuses on requiring reporting and measurement of water use. So those are a couple of the regulatory tools that we're going to talk about, or that we have talked about previously, excuse me. So then the other thing I want to mention is voluntary agreements. We talked about those last week in our informational session, and just want to remind people that those voluntary agreements can be entered into at any time, and that whole voluntary agreement process can work in parallel with the regulatory process that we're going through here with the critical groundwater area. So rulemaking timeline, this is for Division 10, not for Division 512. I want to make that very clear. This is for the Division 10 critical groundwater area designation rules. And so we went through back in December through February, rule development and RAC meetings, March and April. We noticed the Secretary of State's office put it out in the bulletin. There was a public comment period. There were multiple public hearings throughout the state, as well as a hybrid option for public hearing so that any person within the state could comment. And then May 2023, the goal was to, we worked through considered comments that we had received, and then we were working on development of the recommendation for the Water Resources Commission, and actually we've still been working on that even up until through July and August. And now in September, the Water Resources Commission is going to be meeting out in Burns at the end of September, and we'll be presenting our recommendation and then a potential rule adoption for these Division 10 rules. So that's where we are in the process. Is we're in between. We're getting ready to adopt these rules, or the Water Resources Commission is. Ken, I see a question. Is that a accidental hand?
No, I'm sorry. When will the proposed rules be available on your website?
So we're gonna, Kelly, can you answer that? Because I don't remember the exact date.
So September 13th is when we send the staff report to the Water Resources Commission, and then we'll post it on the Division 10. Then.
Thank you.
You're welcome.
Perfect. So that's the timeline. So why was rulemaking needed? Well, the administrative rules, the OARs, didn't match the current statute. So the statute was last updated related to critical groundwater area designation in 1991. And the current rules that exist on the books were last updated in 1990. So obviously there were changes in the statute. The rules don't reflect that. We need to update them. And then, as all administrative rules are supposed to do, these are to help clarify statutory terms, processes, and make it clear how we're going to implement the authorities within the statute. So to call out a couple key differences between the old rules and the new rules. So in the old rules, a critical groundwater area was designated by the state engineer through an order. So essentially the state engineer issued an order and a critical groundwater area was designated. In the new rules, and because of the way the statutes were changed, a critical groundwater area designation now has to happen through rule adoption and the rulemaking process, and the commission has to adopt those rules. So two totally separate processes now, and the new process provides more opportunity for comment on the process of designating a critical groundwater area and offers more opportunity for input. Patty, I see you got a question there.
Yes, just curious, would that commission that could adopt a new rule have state engineer recommendation as a big part of informing them?
Yeah, so it's not necessarily going to be the state engineer. It's going to be the Water Resources Department provides the recommendation to the Water Resources Commission, and then the Water Resources Commission will adopt a rule. Does that answer the question? Okay. So then the second piece of the process that changed was previously there was no process for a contested case hearing and offering the same level of due process protections for water rights as in the new process. And the new process contains a process for essentially issuing a draft order, going through a contested case hearing, providing due process protection for water right holders, and then getting to a final order. So those are the two key differences in the rules. And hopefully we can all agree the new process is more protective and offers more opportunity for public input and comment. So now we're going to start drilling into the actual framework that exists in the new rules that we're proposing. And so really it's a two-phase approach, and we're going to talk about these two separate phases in detail. So first, a critical groundwater is designated in the basin program rules through a rulemaking. That's the first step. We have to designate a critical groundwater area, specify what it is, etc., and put that in rule. And then the second step, or second phase, I should use the correct terminology. The second phase is then groundwater use is going to be restricted through an order after a contested case hearing process. And this is what provides that due process protection for water right holders. So let's...
Tim, I saw you unmute yourself. Do you have a question?
Question in the chat.
No question in the chat, but I saw John unmute. Just want to check if you had a question.
Cool.
Yeah.
All right, looks like Patty, you got your hand up?
Yes, would any restrictions be uniform throughout the critical groundwater area, or would there be various different levels of restriction?
So that is going to be up to the rule process and deciding how, like, what is best for the critical groundwater area and potentially the sub areas within it. And we'll get more into detail on that. And then also it's going to be, again, based on that best available science, trying to figure out what's best for each area within the critical groundwater area. That would then carry over into orders where the restrictions actually happen. So short answer to your question is it's intended to be as specific as possible, to match the specific situation within the critical groundwater area or within a sub area within the critical groundwater area.
Thank you.
Yep. Any other questions before we dig into phase one? All right, so phase one, actually designating a critical groundwater area. So the first thing is we've got criteria for when a critical groundwater area designation can be initiated. And so we have to meet one of these 7 criteria. And those 7 criteria are that the groundwater supply is or is about to be overdrawn, that groundwater levels are declining excessively or have excessively declined, that there's a pattern of substantial interference between wells, that there's a potential pattern of substantial interference between senior surface water right holders and wells. There's a pattern of interference on regulated geothermal resources, that groundwater temperature is or has been or is about to be altered, and or groundwater pollution is impacting public health, or groundwater is about to be polluted. So those are the 7 potential criteria. We only have to meet one of those to designate a critical groundwater area. Key definitions here: overdrawn. Overdrawn essentially means that the amount of pumpage annually exceeds the amount of recharge. So we're withdrawing more water than is coming back in through the natural processes of recharge. The second is declining excessively or excessively declined. So declining excessively is a rate, and that's 3 feet per year for 10 years. So if groundwater levels are declining at a rate of 3 feet per year for 10 years, then we have declining excessively. Groundwater levels are considered excessively declined if they have reached or declined more than 50 feet from the highest known water levels. So we've got a rate-based criteria there, which is declining excessively, and we've got a total magnitude decline criteria there, and that is excessively declined. So John Short, thanks for asking that question. So exceeding recharge, does that take into account use by natural vegetation? That is a good question. And my understanding of the definition of overdrawn is it is annual pumpage exceeds recharge. It does not take into account the use by natural vegetation. So by that definition, essentially, pumpage would have to use all recharge or more than total recharge, which would, over the long term, leave essentially none for natural vegetation. So that's a pretty rough definition for the environment, at least. So,
yep, sounds like it. Thank you.
Yeah, absolutely. Thanks for the question. Okay, so those are the criteria. So now let's start getting into the actual, flow chart here, the process. So to try to abbreviate this, I'm only going to show this slide, I think, once or twice, as opposed to the, 8 times I showed it in the YouTube video. So the first step is that the critical groundwater area designation criteria is met, and we initiate that process. So then step B, we're going to start drafting rules. And those draft rules are basically to put the framework together to start the critical groundwater designation process. So in Division 10, we specifically state that the department's draft rules must define the boundaries of the critical groundwater area. They must include provisions for periodic review, and then they may contain corrective control provisions. So essentially, where is the problem area and what is the problem? And then how often are we going to review the problem? And then how are we going to solve the problem? Those are essentially the three key things that have to be in rule there. When we're defining boundaries, boundaries can be drawn according to the presence of physical, natural boundaries, like such as hydrological conditions, or recharge or discharge areas, or they can be defined administratively. So essentially by drawing a boundary on a map and saying, this is how, this is the area and we're going to administer this. And unfortunately, we're not always able to administer an area based on perfect science and perfect physical natural boundaries. And so we need the option to use both based on the situation. So that's how we're going to define boundaries. The draft rules also, as I said, have to include provisions for how often we're going to review. So if there are no provisions requiring the limitation of groundwater use, so we're just designating a critical groundwater area, but we're not limiting use, then the conditions for the establishment of the critical groundwater area have to be reviewed at least every 10 years. If the rules contain a provision requiring the limitation of groundwater use, then we have to review those rules at least once every 3 years. So depending on the situation and what is going to happen in the designation, whether or not groundwater use is going to be limited, we either have to review once every 3 years at least, or once every 10 years at least. So then we also have to notify the public of the rulemaking. So there's some requirements for how we notify the public about the rulemaking, but we have some additional requirements in Division 10. So we're going to follow the normal rulemaking requirements as listed in ORS 183.335, but then we're also going to notify the owners of record of all groundwater registrations, inchoate transfers, permits, and certificates for groundwater use within the affected area. So essentially, everybody who has a water right within a groundwater right within that area. And then we're also going to notify all tax lot owners within the affected area, but not those that are within a municipal or quasi-municipal water service area. So this was a recommendation from our Groundwater Advisory Committee. They wanted to make sure that we notified as many people that could be affected as possible. But they also recognize that people within a municipality are likely not going to need a letter from us, and that the municipality is going to be taking care of their water service. And so that's why that exception for the municipal or quasi-municipal water service. And then the last requirement is that we'll notify each well constructor who's been licensed under ORS 537.747. And the department maintains a list of who those people are. So I think we've got another question there. So John, looks like you asked, if review finds reasons to change the order, does it have to go through the same entire process? So if conditions change and a rule is no longer necessary or should be modified, then yes, we have to go through the same rulemaking process to change the rule. If that is then changing the groundwater use, restrictions on groundwater use, if it is restricting more groundwater use, then we have to go through the contested case process. If it is easing off restrictions, we don't have to go through contested case process because we're not removing a right from anyone. We would be giving people back the ability to use their right. Does that answer your question there?
Yeah, that sounds good. Thank you.
Yep. Okay, cool. All right, so those are some of the things that are happening there in step B. I then want to get into the corrective controls that could be written into rules. So these are the corrective control provisions, essentially the how do we fix the problem in rule. And so we've got these 6 different provisions that could be written in here. The first one is a provision closing the critical groundwater area to further appropriation, and it allows the department to refuse any new applications. So this is basically saying, like, we can put a moratorium on new groundwater rights in the critical groundwater area. The second is a provision determining the permissible total withdrawal of groundwater in the critical area each day, month, or year. So here we can specify how much pumpage is allowed in each within the critical groundwater area, and potentially within each sub area within the critical groundwater area by some time unit. And most likely it will be per year. Getting more detailed than that can become problematic for a number of reasons. And so likely we will use per year. Another criteria or another provision here is the disposition of any application for a water right permit that was pending at the time of the rulemaking process starting, or that was received during the rulemaking process. So essentially, again, we can decide how to deal with any permits that were outstanding, or that permit applications that were outstanding, or permit applications that came in during this process. Again, it doesn't make sense to issue new groundwater rights if we're going to be restricting groundwater use. Another provision here is any one or more provisions making such additional requirements as are necessary to protect the public welfare, health, and safety. So this is obviously a very broad option, like a broad provision here that's allowed. And these would be used for very specific situations, right? So I don't have an example for you. And so just know that there's a lot, like this is a big, broad option here. And it allows for a wide variety of solutions to whatever the potential problem is. The next provision is a provision closing all or part of the critical groundwater area to further appropriation of groundwater for its thermal characteristics. So essentially, this is trying to get at the potential problems with alterations to temperature. And so we can go through and restrict appropriation of groundwater for its thermal characteristics, right? So people that use it for geothermal projects. And then the last provision that's allowed to be in rule is a provision determining the permissible change in thermal characteristics of groundwater in all or part of the critical groundwater area each day, month, or year. So this would allow for a certain amount of potential change in groundwater temperature or groundwater temperature characteristics within the area. So maybe we accept that temperature declines of, I don't know, a degree per year is acceptable. And so, we're going to put that in a provision. The last two here are not really going to be addressed in the Division 512 rulemaking because that's not what we're focused on. We're focused on declining groundwater levels. So any questions on the corrective controls that are allowed in rule? Okay. So also, Ken, go ahead.
Wasn't that statutory language?
Absolutely, yes.
Okay, so are you just repeating the statutory language in the rule?
We are, yes.
Okay.
And that was mostly for ease of reading. As you're reading through the rules, you don't have to reference the statute. You can just read it right out, right there. So one more thing we're going to be doing while rule drafting begins is we're going to be developing a groundwater report. So this report that's being drafted is going to support the critical groundwater area designation process. It's going to be developed prior to the RAC, and it will be posted as a draft report on the department website. The report is going to be is required to be based on the best available science, and it's going to identify the criteria that have been met under the statute. So those 7 criteria we talked about at the beginning. It's going to identify and characterize the groundwater reservoirs subject to the proposed critical groundwater designation. So it's going to essentially lay out, here's what the groundwater reservoir is, and here are the characteristics of that groundwater reservoir. And then it's going to identify corrective control provisions or corrective control measures likely to resolve the problem, and that resulted in the recommendation to designate a critical groundwater area. So again, this report is basically backing up the requirements of what's going to be in the rules. So what's the problem? What's the criteria that was met? Where is the problem? Why is this how do we define this groundwater reservoir? And then how do we solve the problem? And why are these things why do we believe these things are going to solve the problem? So that's the intent of the groundwater report. We're then going to allow public comment on the report. So the draft report gets published on the department's website prior to the rulemaking, or prior to the forming of a rulemaking advisory committee. And then until the close of public comment period, consistent with ORS 183-335. So that's the public comment period for the entire rulemaking. The department is going to solicit and accept information and comments from the public regarding the draft report. So we're putting forth, here is our problem statement, here is our science backing that up, here is how we believe we can solve the problem, and then the public has the opportunity to present information and comments on that report. So then at the end of that public comment period, the department will review the information and comments received and present a final report to the commission that includes the department's findings and conclusions and includes an assessment of the information and comments received. So essentially, we're going to take all that information, all that public comment, we're going to review it, we're going to evaluate it, and we're going to provide an assessment to the commission on those comments and information, as well as our final report. And this final report then gives the commission the information they need to understand why the critical groundwater area designation is being recommended and why the rules are written the way they are and why the corrective control provisions that are written in the rule are the ones they are, right? So essentially, what's the problem and how do we fix it? Any questions on that process? Ken?
I presume that the report will be where you provide the permissible total withdrawal
No.
information.
No. So it will recommend what of those corrective control provisions, right? So of these 6 possible provisions, which ones we believe will help resolve the problem. But it is likely not going to get into the specifics of, we believe that pumpage should only equal this in this area to resolve the issue. That is going to happen as part of the rulemaking process as we're drafting the rules, and the RAC is going to be able to provide input on that process. That's the intent, at least. Does that answer the question?
It answers the question. It's just, it seems like that's critical information that the sooner it comes, the better people could deal with it.
Absolutely. The challenge or the interests we're trying to balance there are the interests of allowing the community to have public input and using the science to get to a number, right? And we're trying to balance those effectively and have a collaborative community conversation rather than having it look like the department is simply telling people, this is what you shall do, and there's no room for discussion. So that's our intent, at least. So.
Understand. There's also an argument that if people know what the targets might be, then they could worry about voluntary agreements or other ways to approach those, which is just a different way to look at the same elephant.
Sure. I appreciate that. Thank you. All right. So we've now finished A and B. We're going to go on through C through G. So in C, we're going to take the groundwater report that was developed, that draft report that's published on the department's website, and we're going to use that to coordinate with affected local governments related to land use planning and to consult with federally recognized Indian tribes. So affected local governments that have a land use planning nexus, we need to coordinate with them so that they understand the impacts of a critical groundwater area designation. And then we want to provide the opportunity for federally recognized Indian tribes to consult with us and to provide input into the rulemaking process. So that's going to happen prior to the Rules Advisory Committee being formed. So now we're going to get to step D, and we're going to initiate a RAC, or we're going to form a rulemaking advisory committee, and we're going to follow the requirements for that rulemaking process of the Administrative Procedures Act. And that's all pretty well spelled out in the Administrative Procedures Act, and we're not modifying that process. So then, as I said, we're going to notify of the rulemaking. We're going to have already notified that broad swath of people, owners of groundwater records, tax lot owners, well constructors. And then we're going to get to actual rule notification, where we notice the Secretary of State's office. And that process, again, follows the Administrative Procedures Act. And then at least 60 days after the notice of the proposed rules, the department must hold at least one public hearing in the affected area. So we're going to get to step F, which is where we're going to hold public comment and public hearings. And we must hold at least one public hearing in the affected area, so within the critical groundwater area. And I believe we gave ourselves the ability to hold the public hearing either in the affected area or in the most reasonable place close to the affected area, because it's possible one of these critical groundwater areas could literally be out where there are no structures, no buildings. It doesn't make sense for us all to stand out in a field and have public hearing. Let's go to the nearest place that's feasible for a public meeting and work there. So we gave ourselves a little bit of leeway there so that we're not, standing out in the middle of a field somewhere with a tape recorder trying to take public comment. And then finally, we get through that public comment and public hearings, and we're going to present to the commission a recommendation, and the Water Resources Commission is then going to adopt the rules if they agree, obviously. And once the rules are adopted, they'll be filed with the Secretary of State. And then within the statute, we're also required to file them with the county clerk of each county within which any part of the critical groundwater area lies. And the county clerk is to file those in the deed records of the county. So that's a very specific thing that they do, but essentially they're going to put it in their records of the county. And so that concludes the phase one, the rulemaking process to designate a critical groundwater area. So at the end of this, there is a map with a critical groundwater area boundary, potentially sub areas within that, and some corrective control provisions that apply to that to try to help solve the problem. But we haven't actually implemented any restrictions other than potentially denying new groundwater applications. We haven't put any restrictions on actual groundwater use. And so that's where we go to phase two, which is an order that must go through the contested case process. So before we do that, are there any questions on phase one, rulemaking, critical groundwater area designation? Okay, so phase two. And I redrafted some of these slides to try to make it flow hopefully a little bit faster and be a little bit clearer. But basically the first slide here is two processes. And basically we're going to prep an initial notification of corrective control orders, and we're going to deliver that initial notification. That's essentially the department saying, hey, we're going to be issuing an order, and we're notifying all of you that we're going to be issuing an order. And as part of that process, we also ask or provide an opportunity for anybody who is not going to be named in the order to request a copy of the orders. So if you are not a groundwater right holder or potentially an exempt user who would be restricted by the order, you can, if you believe that you would like to see the order or that you have an interest in the order, you can request a copy of it. And when you do that, you can request either that the order be sent to you by mail or email. And so we're trying to digitize as much as we can and streamline that process for notifying people. And we'll get into the specifics of how we notify here in a bit. So that's the first piece, is we send out a, hey, we're going to be issuing an order. Then we're going to prep a notice of proposed corrective control orders. And this proposed corrective control orders, you can essentially think of as a draft order. And so we're then going to deliver that to people. We're going to deliver that to the parties affected by the order, but also to anyone who requested a copy of that order after the initial notification. So those are the two steps we're going to talk about here really quickly and drill into just a little bit more. So corrective controls in order. Now, these are going to look a lot like what was allowed in rule. The difference here is these are the provisions that will go into it. They're allowed in an order that basically implement what we put in rule. So the first provision is a provision apportioning the permissible total withdrawal as established by rule among the appropriators holding valid rights to groundwater in the critical area in accordance with the relative dates of priority of such rights. So in lay terms, what that means is we're going to take the permissible total withdrawal that was established in rule, how much is allowed to be pumped, and we are going to divide that up, starting with the senior right holders, and going down the list of right holders from senior to junior. And at some point, we will run out of permissible total withdrawal or allowed pumpage. And everybody below that line in the priority date scheme will not be allowed to pump groundwater. And so that's how permissible total withdrawal gets converted from a rule, like a number in rule, to actual curtailment on the ground at the end of the day through an order. So the second provision is a provision according preference. And there's a lot of language here, but basically it allows the commission through an order to provide preference for residential and livestock watering purposes first, and then based on priority date, these other items. So the commission can essentially tweak the priority system just a little bit, but specifically for residential and livestock watering purposes first. The next potential provision is where 2 or more wells in the critical area are used by the same appropriator. We can set a provision adjusting the total permissible withdrawal of groundwater by such an appropriator, or a provision forbidding the use of 1 or more such wells completely. So essentially, the order can specify, hey, you have 2 wells on this groundwater right, you're allowed to pump X amount out of your first well and Y amount out of your second well. That adds up to your permissible total withdrawal. Or we could say, hey, you're only allowed to pump out of well number 1 and not out of well number 2. So that's possible in an order. The fourth provision here that's allowed is a provision requiring abatement in whole or part or the sealing of any well in the critical area responsible for essentially pollution. So this allows us to force remediation of wells that are causing problems within the critical groundwater area. And then the last provision is a provision requiring and specifying a system of rotation of use of groundwater in the critical area. And that's as simple as it sounds. We can essentially, through an order, specify you get water at this time, and then you get water, and then you get water, and then you get water. And that's some sort of rotation scheme for use of groundwater in the critical area. So those are the 5 provisions that are allowed in an order. So those are what can be written into the order to actually restrict groundwater use or to force action, fixing a well, or mandating how groundwater is going to be either rotated through or where it's going to be pumped out of, one well or another, etc. So any questions on the corrective controls that can go into an order? Ken?
Sorry. It seems like, particularly with the permissible total withdrawal, the how tightly or broadly you specify that will have a significant effect on who's affected and who's not. If you, for example, if you have a permissible total withdrawal that's defined just by the Weaver Springs area, that would be one way. It would affect the users there. It wouldn't affect users in other places. And you could have a different permissible total withdrawal from other parts where the decline is significantly less. So the real question is there going to be a single permissible total withdrawal for the entire basin, or will it be flexible enough to have sub areas where you identify permissible total withdrawal for sub areas that could meet the overall goal for managing groundwater?
So that, I'm going to say, for the purpose of this presentation, that is yet to be determined. The rules give us some flexibility there. For the purposes of Division 512, some things we've talked about internally and that we're going to talk about with the community in the RAC from my perspective, it makes a ton of sense to have the permissible total withdrawal set by sub area, and then you add all those up and you get to the critical groundwater area total, right? So you do what needs to happen in each specific area, and you set the limits necessary for those areas. Then you add all those up and you get to a total for the critical groundwater area. You likely don't start with here's what we need to restrict for the whole area, and then figure out how to divide that up. I think it makes the most sense to work backwards, not backwards, the other way around. That's what I mean.
Cumulative.
Cumulatively, yes. Thank you. That's the correct way of saying it. But again, conversations for the RAC, and we'll be discussing that as we go through the process. So the rules allow us to do either one.
Thank you.
Yep, absolutely. Any other questions on the corrective controls allowed in order? All right. So now let's talk notifications. So when we're sending notifications for the initial notification of corrective control orders, which is essentially the, hey, we're going to be issuing an order, we've got 3 different ways in which we are required to send that notification. So first is first-class mail. We have to send that to affected local governments. We have to send that to federally recognized Indian tribes, and we have to send that to property owners of tax lots within the critical groundwater area. So that's essentially like everybody that exists within that critical, or that owns property within that critical groundwater area, or potentially has an interest as a governmental entity or as a federally recognized Indian tribe. The second is publication. So we're required to post in the OWRD weekly bulletin for 4 weeks. We're required to put it on the OWRD website, and then in the local newspaper for a minimum of 2 weeks. And then the last is we're required to hold at least 1 public meeting within the critical groundwater area to let people know, or to essentially talk about this initial notification of corrective control orders. So that's that initial, hey, a draft order is coming. So now, here are the notification requirements for the actual notice of corrective control orders, which is that draft order. So we've got 4 ways we can deliver that. So the first is by certified or registered mail, right? So that's a little bit more strict on how it's delivered to people. And by certified or registered mail is required for groundwater right holders and exempt users whose groundwater use would be limited. So for the purposes of Harney, because at this point we haven't talked about limiting any exempt users, we would not send this to exempt users. We would only send it to groundwater right holders in the basin. If we were working in a critical groundwater area where exempt use needed to be limited for some reason, then we would have to notice all exempt users whose groundwater use would be limited. So then for the people who are not groundwater right holders or exempt users, so these are people or entities who have requested a copy of the notice of corrective control orders, they could specify whether they wanted to receive it by regular mail or by email, and we will then honor that. So they'll get it either by mail or email. It's up to them. When they request the copy, they're going to have to choose their preferred contact method. And then the last method for putting out this notice is, again, the OWRD weekly bulletin for 4 weeks and the OWRD website. So those are the requirements that go into that first step of this process, which was essentially saying, hey, we've got a draft order coming, and then actually issuing the draft order. Here it is. So now, if there's no questions on that, we'll move on to preparing for the contested case hearing. All right. Seeing none, let's talk preparing for this contested case hearing. So once that draft order has gone out, people who are named parties, so groundwater right holders, exempt users whose groundwater use is going to be limited, have the opportunity to file a request for hearing, which basically says like, hey, we want to participate in a contested case hearing. And they provide that information to the department. Or interested parties who are not named in the order may file a petition for party status. So they can say, hey, we believe we should be party to this contested case because we have an interest in it, and we can present on our interest there, and it's important that we do. So for petitions for party status, WRD is required to notify all named parties of any petitions that are received. So we push those petitions out to named parties. They have a period of time in which they can respond to those petitions. And then after that, WRD gets to decide on the petitions for party status. And for granted petitions, the Water Resources Department gets to specify the areas of participation and any procedural limits on those petitioners when they petition for party status. So if we're going to grant party status, the department can specify you're only allowed to participate in these areas, and here are the procedural limitations that will fall on you. With the intent being, we're really trying to address the parties named in the order, and we're also trying to give an opportunity to the specific areas or issues that may not come out through with the named parties, but are important to discuss in a contested case hearing. So once we have our requests for hearing deadline has passed and we've received those requests for hearing, and once the petitions for party status deadline has passed and we've made decisions on all those petitions, then we can essentially prepare a list of issues and refer the matter to the Office of Administrative Hearings, who's actually going to conduct the contested case hearing. But this is basically, we're getting ready, and now we're going to take all of the issues that need to be discussed in the contested case hearing and heard in the contested case hearing, and we're going to forward that over to the Office of Administrative Hearings and say, hey, we need to conduct a contested case hearing. Here's everything we've got. Let's get started. So any questions on preparing for the hearing? Okay, and there's a lot more detail.
Yes.
Oh yeah, okay, John, yep, absolutely.
In referring to the OAH, if their current backlog is something like 10 years, will this be right in there with the rest of the backlog, or does it somehow get moved up sooner? Just a question.
That is a fantastic question. And because I don't have a ton of experience with this, I am going to see if Ivan has any understanding of if we can jump the line or not. If Ivan's still here.
He ran for his life.
Yeah. I will say what we have discussed, John, is that for urgent matters, we should have the ability to essentially add priority to our issue and be heard sooner. That's what I've been told.
Most of my clients think they are urgent.
Sure. Yeah.
We'll be working with the Office of Administrative Hearings ahead of time to get these scheduled out front. And it'll be a priority to deal with these for the department. So.
Yeah.
Thank you.
Any other questions on preparing for the hearing? All right. Keep moving. So now we're going to conduct the hearing. So the Office of Administrative Hearings is going to assign an administrative law judge. That administrative law judge is then going to move us through the process of a contested case hearing. And when I say us, I mean all parties as well as the department. That contested case hearing is going to be conducted following the rules and requirements of contested case hearing process. There's statutes and administrative rules that apply to that. And Division 10 has a few specific things that are called out and modified in that process. And I'd urge you to read the draft rules or listen to the YouTube video for more specifics on that. And then the last piece is that once the contested case hearing is concluded, the administrative law judge is going to issue a proposed order. So essentially, they're going to say, here's what we think should be done. Here's the order that we believe should be issued. So that completes the hearing. But now people have the opportunity to file exceptions to that proposed order. So they have 60 days. They can file exceptions. And then the Water Resources Commission is required to consider all timely filed exceptions. And then in considering those timely filed exceptions, they eventually reach a conclusion and they'll get to a final order, which will be issued. And then at that point, WRD will regulate per the final order and restrict groundwater usage based on what is in that order. And so that's how we get to actual restriction of groundwater use. Or another way of saying it is this is how we get from what was said we were going to do in rule to boots on the ground actually implementing those rules. So any questions on phase 2, which is the contested case process? Okay, and I am like right on schedule here. And so let's talk about modification of existing critical groundwater areas. So in the Division 10 rules, we built in the ability to modify critical groundwater areas, essentially following the same steps as are listed in phase 1 and phase 2, as we've talked about here. But we're going to talk about a few reasons for that to try to help make it clear why we put this in. So first, there's 7 existing critical groundwater areas. I've got a map here to try to break up the monotony of text. The red on this map are the current critical groundwater areas. It looks like there's only 1, 2, 3, 4, but there are multiple critical groundwater areas within here. So there's actually 4 here. There's Ordnance Gravel, Ordnance Basalt, Sage Gulch, and Butter Creek, and then the others. So those are the 7 that exist. And the goal within Division 10, the modification portion of Division 10, was to give us the capability to modify the designation based on the best available science. And this applies not just to the existing critical groundwater areas, but we also wanted to be able to, in the future, say with the Harney critical groundwater area designation, if 10 years down the road, we find better available science and it says we need to modify something, we need to be able to go back, open up those rules, make changes, and try to be adaptive to the situation on the ground. And so that's the broad reason for having a modification rule within our Division 10 rules. So some reasons for modification, like I said, new data suggests potentially boundaries of a critical groundwater area or a sub-area may need to be adjusted. The original permissible total withdrawal may need adjusting. Management of the groundwater reservoir needs to be adaptive and flexible, as I said, right? We want to change with the conditions and we want to be as effective as we can be. And then the last is that we've got 2 early critical groundwater areas that were designated that require significant staff time to allocate groundwater annually to senior users. And it doesn't provide much benefit to anyone. And we want to modernize that process and provide more certainty for water users and to reduce staff workload so that we're not grinding on a bureaucratic process that isn't providing benefit to the citizens of Oregon. And those are the key reasons for modification. So any questions on that? Or any questions on the entire process? We've gotten to the end there, and I think I see one in chat. Which areas are the 2 troublesome ones? Thanks, John. We have to do allocation, I believe, in Sage Gulch and Butter Creek. And just for reference, it takes about a month of staff time for each hydrogeologist that covers that area to put together those allocations. And so it's a substantial amount of time that they could be spending doing science or all kinds of other things. That would be a better use of their time, in my opinion.
Yep. Thanks.
Yep. Ken, question.
Yeah, understand that this will be a new process for the agency. Do you have any ballpark estimate of the time that it will take to, 1, designate the critical groundwater management area, and then 2nd, to develop the corrective control measures, since they're 2 separate processes?
Ivan, do you want to take a whack at that, or do you want me to take a whack at it?
Oh, I can. Our first example under this new process is likely to be the Division 512 rules for Harney. That is scheduled to get wrapped up. The rule process, which would designate the critical area and lay out the sub areas, is scheduled right now to hopefully go in front of the commission in June of 2024. So essentially 10 months from now. The racks would get wrapped up very early next year. There'd be a public comment period, the various other parts of the processes, and then get that in front of the commission June of 2024. At that point in time, well, let me back up. At the same time, folks will be working on voluntary agreements. The Harney CREP program will be operational, and we'll see what kind of interest we get in those two opportunities for folks to step up and voluntarily start reducing their groundwater use as soon as they can. Depending on that response, the department will make a decision potentially to move forward with the contested case hearing process. That's phase 2 of what Tim talked about today. And you saw the large number of steps involved in that process. And so my best guess is that, well, there's decisions that can be made. The likely outcome of the Harney critical groundwater area designation, at least the way the department sees things, is that there's one critical area boundary, and within that will be some number of sub areas yet to be determined, you know, discussions with the RAC, so on and so forth. The decision point will be for the contested case process. Would the department move forward with curtailment in all of those sub areas or just in one or two of them? And that, of course, brings in different numbers of water rights and likely different numbers of water right holders, all of which get their due process and will want their say and their day in court. So it's really hard to say, but I imagine that contested case process can be no faster than 2 years. 3 years might be a more reasonable likelihood. And that's once it is initiated. So we have to, again, we'll try and be scheduling out in front with the Office of Administrative Hearings. And there we go. So, you know, June 2024 plus 2 to 3 years to get through the contested case hearing process is our best estimate of time that we have.
Thank you.
You bet.
Hey, Ivan, I just want to clarify. It's September 2024 on our rulemaking timeline.
Oh, September.
So
Okay.
I just want to make sure since we're recording and we showed the rulemaking timeline at the beginning, I don't want folks to be confused. It's September 2024.
In 3 years, 3 months aren't going to matter much.
I thought I saw Alexandria. I thought I saw June on another PowerPoint. So we need to look internally and make sure we got the same thing here. Any other questions?
All right. Well, if there aren't any other questions, I want to thank everybody for your time and your excellent questions today and your engagement. I really appreciate it. I really appreciate you attending, coming prepared, having watched the YouTube video. That's very obvious. Many of you have done that. I really appreciate that. It says a lot for the engagement here, and I'm excited to get to the next RAC meeting next Tuesday, August 29th, 1 p.m. at the Harney Community Center, or online. We have a virtual option as well, and we will continue forward with our rulemaking process. So, Alexandria, I'll turn it over to you. You can wrap it up.
Thanks, Tim. Well, I think you hit all of the major points. Just want to thank everyone for your time and your participation in these learning sessions. They're important not only for the Rules Advisory Committee, but the broader community in general. So we encourage you to point out these resources to your neighbors, to your friends, because we really want to build that foundation for the community so that we can have fruitful conversations, both on the regulatory side, as well as setting the community up for success for voluntary agreements, and implementation of the groundwater portion of the place-based plan. So we Again, thank you for your time and your willingness to engage with us, ask questions, learn together. This is a new framework and a great time to kind of get these questions answered before we enter the next RAC meeting. If things come up between now and the next RAC meeting, please email Kelly Mines with those questions. Kelly, I'm punting those questions to you as you worked closely on the Division 10 rulemaking. I will not name myself as an expert on that. So if you have questions on the Division 10 rules specifically, please look to Kelly for those. And we will hopefully see you all next Tuesday at the second RAC meeting. So thank you so much for your time. Enjoy the rest of your afternoon.
Thanks, everyone.